Legal dictation start. Admittedly, the appointment of the appellant came to be made on 18 April 1985 prior to the commencement of the year of recruitment as prescribed under these rules. Full stop. We note that the learned counsel for the appellant was unable to establish before us that this objection noted in the government order dated 23rd September 1985 was either unjustified or unsustainable. Full stop. In our considered view, this objection noticed in the impugned order dated 23rd September 1985, was sufficient to sustain the termination of the temporary engagement of the appellant. Full stop. However, since much argument was advanced on the issue of commencement of the 1985 rules, we proceed to deal with this contention also hereinafter. Full stop. Para. Reverting to the fact of our cases, we find that the contention advanced on behalf of the appellant must necessarily fail on the same ground. Full stop. As has been noted by us in some detail, the only submission urged was that the rules would be deemed to have come into effect only from 31st August 1985 when they came to be published in the official gazette. Full stop. It was not the case of the appellant that the 1985 rules framed on 16 March 1985 were not published or made known to the concerned or affected parties by any other reasonable mode of circulation or publication. Full stop. In fact, the assertion in the Reed petition was that although the rules came into force on 16 March 1985, they were not retrospective and would not apply to selections made before the said date. Full stop. Before the learned single judge, the sole contention advanced was that since these rules had been published only on 31st August 1985, they would be deemed to have come into force only from the said date and not from 16 March 1985. Full stop.